All right. Oh yay, oh yay, oh yay. The Fourth Court of Appeals of the Fourth Appellate Judicial District is now open pursuant to call.
Good morning, please be seated. The court will now call cause number 0422-280 CB, the matter of Harbor America Central Inc. versus Vielka Armand. I invite announcements first from the appellant.
Sure. My name is Armand. I represent MO for Council Chair Gray House. I represent Harbor America Central Inc.
Very good.
Morning, Your Honor. I'm looking very for the appellate deal.
Very good. Imagine you'll be, you've already been instructed about time and whether you'll split arguments. So I'll invite the appellant's counsel to proceed.
Yes, sir.
So may it please the court, I'd like to give, I think it would be helpful for the court to get a little background as to professional employer organizations and kind of their roles with the client companies and the covered employees. Initially, a PEO was done through a contractual matter, but nearly every state has adopted now what's called the Professional Employer Organization Act, including Texas. The only one that has not, that I'm aware of, is California, but their case law is consistent with the principles of the PEO Act, as I'll refer to it. PEOs originated in Florida, and they were basically, the purpose of a PEO is to assist a small business in running payroll, acquiring workers' compensation insurance, employers' practices liability insurance, and other ancillary products. And the reason that the PEO is able to do so is, in the case of Harbor America, for example, they have 500 between the parent company and all of its sister companies and subsidiaries, there's about 550,000 worksite employees. So that allows them to scale the work comp plan and the benefits plans, as well as the EPLI coverage. So it's a huge advantage for the small employers. Unfortunately, when they were first originated, there was not much statutory authority in place. So there was an organization formed called the National Association of Professional Employer Organizations. And they do an extensive amount of lobbying, both on the federal level and the state level, to implement the PEO Act, which, as I mentioned, Texas has adopted. Over the years, the terminology has evolved. Originally, they were called leasing companies. Then it went to PEOs. And then as far as the covered employees, they were originally called leased employees, then co-employees, and now most of the statutes go by covered employees. Until 2013, Texas had labeled them as Staff Leasing Services Act, but it was the same Texas Labor Code, section 91.001 EDSEC. So that's kind of the history of it and how they've evolved over time, and they've really become big business. And ADP has their own form of PEO. The big difference when you talk about a PEO is the statutory versus the common law employer distinction. And as it's been briefed, common law deals with control, while statutory is merely a function of what I just described, which is administering the workers' comp, the payroll, and the EPLI coverage. It's very clear in the PEO Act that's been adopted across numerous states, including Texas, of course, that the control of the employees and the way they conduct their business is still subject to the client company of the PEO. Just to give the court a little flavor of the procedural history on this case, the plaintiff originally filed suit on the 1st of February in 2018 against 10 defendants, one of which was Harbor America, and as well as the client company Legal Eats LLC and some affiliated companies of that, like Legal Eats LLC. And then, of course, the tortfeasor in this case, which is a gentleman by the name of Larry Perryman. The alleged tort was continued sexual assault and harassment, which ultimately culminated in Mr. Perryman following the plaintiff into the freezer of the client company and sexually assaulting her, allegedly. Harbor America's contract, it has an indemnification clause. It's not necessarily an issue in this appeal today, but it is pertinent to Harbor America's liability consistent with the Texas laws as the legislature has enacted it, that it's the sole responsibility of the client company to supervise and be responsible for the actions of the employees. Harbor America then filed a motion for judgment pursuant to Chapter 91. It's which states, amongst other things, it didn't exercise the requisite control and therefore it was protected under the PEO Act as from liability, but it was denied in a one-sentence order. Harbor America then filed a motion for reconsideration, which was also denied and did not include any findings of fact or conclusions of law, though they were requested. Given the clear language of the PEO Act. Later, the plaintiff non-suited all of the defendants except Harbor America and then filed its own motion for summary judgment against Harbor America that it was the employer under Chapter 21 of the Texas Labor Code, and did so by continuing to categorize the relationship as a staffing relationship and using the antiquated language of the staffing leasing service company.
Mr. Barnwell,
Yes, ma'am.
we know that, so there's a service agreement between Harbor and Legal Eats, correct?
Yes, ma'am.
And it comports with Chapter 91 with the requirements of such a PEO contract, right?
Yes, ma'am.
So one of the things that it has here is that Harbor America and clients share the right of direction and control over staff. Is that supervision? What is direction and control?
I will explain that, and I had intended to explain that, why it has those lists of they share this, they share this, they share that. And that is because the PEO doesn't want us the ability to protect their workers' compensation book from blowing up, so to speak, where there's accidents and the client company isn't doing anything about it to stop it.
But as worded, it's not limited to workers' comp. It's very broad. Do you agree it could encompass supervision?
It could encompass supervision, but it's limited to what is contained in the CSA.
And so I'm going to jump around a bit. So
Sure.
Is it enough to have the right to direct and control, i.e. supervise in the contract, or does there have to be an actual exercise of that right?
I would argue that there absolutely has to be an exercise of that right, which is not present in this case. In Texas law,
And is there authority that you can point us to on that?
sure, Texas Labor Code 91.001, the client states that the client company remains, quote, obligated to perform those employer obligations allocated to the client by the professional employer services agreement or Chapter 91, as well as those, quote, specifically allocated to the PEO in the services agreement or Chapter 91, one of which states, quote, client shall continue to have the exclusive right of control over the operation, management, and control of its business and staff.
And what are you quoting from? I'm sorry.
That is Section 3B of the CSA. which would be the client service agreement between Legal Eats and Harbor America.
And what under 3B, so you referring to 3B, what are those express responsibilities in the CSA? It says Harbor America assumes only those responsibilities expressly allocated to Harbor America under the terms of this agreement or required of Harbor America under applicable state law regulating professional employer organization services. So what are the express responsibilities allocated to Harbor in this agreement?
I think the document speaks for itself, Justice. To administer the payroll, properly withhold the taxes, administer the workers' compensation, and then provide the EPLI coverage. That's the crux of the service agreement.
Okay.
And then moving forward, Texas Labor Code Section 91.032B states that the client company retains sole responsibility for the direction and control of covered employees as necessary to conduct the client's business, discharge any applicable fiduciary duty, or comply with any licensure, regulatory, or statutory requirement. The goods and service produced by the client company and the acts, errors, and omissions of covered employees committed within the scope of the client's business. So that when you talk about the statutory employer versus the common law employer, it really, has been thoroughly briefed, it all comes down to control. Who's controlling those employees? If the statutory employer merely administers the payroll and does the things outlined in the context of the CSA and is permitted under Texas law, while the common law employer is the one running the day-to-day operations and essentially controlling his employees and their hours and remitting payment to the PEO so that the PEO can then withhold the taxes.
Let me interrupt you if I may.
Yes, ma'am.
I know that in your argument as well in your briefing, you sort of argue both. Two issues before us. What do you understand them to be?
I think the two issues are whether they are employees of Harbor, whether the plaintiff is an employee of Harbor America under Chapter 21, or whether Chapter 91 protects the PEO in situations such as these.
Let's back up. First, we have to determine under this somewhat restricted appeal that whether or not Chapter 91 supersedes Chapter 21. And in conducting a statutory construction of this on appeal, that's your burden to show that these statutes are irreconcilable. How are they? Without getting into whether or not the plaintiff in this case can establish liability, let's answer the question whether they can be.
Sure.
Because we know it is presumed that the legislature in enacting statutes that they do so in a way that is not inconsistent with other laws or the Constitution. And we know that the laws disfavors a ruling unless an opponent or an appellant like yourself can establish that it does in fact supersede one statute over the other. In what way are the applicable provisions under Chapter 91 irreconcilable to any provision in Chapter 21?
Second, Justice, I apologize. Well, it's cited by the appellee.
Oh, no. How did you show downstairs, and why should we determine that the trial court erred in disagreeing with you that that both chapters are not irreconcilable? So what is your position?
My position is they are irreconcilable.
And how is my question?
Is because I'm trying to not be repetitive here, but
No, most of your argument has been under your second argument of whether or not whether the act abrogates the common law doctrine of the employer-employee test. That's your second argument. I'm focused on your first.
okay.
We must determine whether the claims in this case as pled are appropriate, recognized under the statute. Your position on appeal is that it doesn't, that under Chapter 91, any that the POEs fall under Chapter 91 and do not fall under Chapter 21, because 91 supersedes Chapter 21. How so?
It's the control element.
Control is under the common law stuff, but if that's your argument, proceed.
Yeah, I mean, yes, ma'am, that
What
is,
provisions of each statute are completely irreconcilable under any scenario, not just yours, under any scenario? Pointing to any language in the statute, because that's on review what we need to look at. It would appear that Harbor does not challenge whether or not Armand actually proved through undisputed evidence that it met Chapter 21's definition of employer. Is that correct?
I would disagree.
Where in your brief did you submit that in fact you do not fall under the definition of employer under Chapter 21?
In
And
the,
is it not undisputed that you have 15 or more employees?
oh, it's absolutely undisputed that there's more than 15.
So how is it that Harbor, for the first time on appeal, to challenge whether or not Armand proved with undisputed evidence that it met Chapter 21's definition of being, quote, engaged in an industry affecting commerce? Why would you dispute that? How are they not engaged
I
in
do
an
not
industry affecting commerce?
I do not dispute that.
Okay, so it is undisputed
Yes,
that you do not fall, that Harbor falls under the definition of under Chapter 21 of being an employer, correct?
I agree that
What I understand Harbor's argument as briefed
yes,
is that you simply argue that regardless of these undisputed facts, that the Chapter 21's employer definition simply just never applies to you because it's a PEO licensed under the Act, and that the rules of statutory construction require the court to read the Act to supersede Chapter 21 in its entirety. Please explain and elaborate on that position.
I think the conflictory nature of them, of those two statutes, and again, it goes back.
And how are they conflicting, or in better terms, how are they irreconcilable?
Because in Chapter 91, it says that the PEO can't be responsible for the client company's employees' acts, whereas Chapter 21 says
Let's point to the specific provision if you can.
in Chapter 21,
Well, which provision you're saying is in conflict with another statutory provision?
It looks like I'm running out of time, but I
I asked because it is not well briefed. In fact, it's only about 4 paragraphs in your brief on to answer that specific question. But that is under the first issue, the only thing that's before the court, along with your secondary point about whether or not it also abrogates the common law employer-employee test, which I know you've briefed a little bit more than you did, but this one seems to be in need of elaboration.
Judge, I think my time is up, so I will allow Mr. Griggs to make the argument, and then I will be prepared to rebut it.
Very good.
I
Thank
have
you.
one question
Yeah.
before you sit down. So we know that chapter 91, section .002C says that nothing in this chapter preempts the existing statutory or rulemaking authority of any other state agency or entity to regulate professional employer services in a manner consistent with the statutory authority of that state agency or entity. So can you explain to us why this doesn't allow for chapter 21 to come in and to be considered, for there to be liability for a PEO under chapter 21, given 91.002C?
I would again just say it's the 21 is not applicable because the Harbor America did not exercise the requisite control to make them subject to chapter 21 of the Labor Code.
As a follow-up, what support is there that in fact they had to show that they had to actually exercise control as opposed to simply having the right to control?
Well, the right is statutorily required for the reasons that I mentioned, which is, they don't want their premiums to explode because they don't have the ability to exercise some sort of control over worksite employees who may be high risk for work comp, for EPLI, and other ancillary products.
Very good. We'll hear from you back shortly.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court. My name is Bill Grigg. I represent the appellee, Armand. 550,000 worksite employees. That's the number that Harbor cited as the number of workers that fall under the conglomeration of Harbor America and its sister and parent companies. So I want the court to understand the stakes here. Now, Harbor America is saying because Chapter 91 applies to it, Chapter 21 can't apply to it because it's only governed by Chapter 91. So that same extent, I don't see how under their arguments you come to any logical conclusion other than a PEO is never liable under any other employment law. The case law is clear, both federal and state, that a civil rights statute, and Chapter 21 is a civil rights statute, needs to be applied broadly. And the definition of an employer under that statute needs to be applied broadly. And Harbor America is asking for that definition in this statute, a civil rights statute, to be limited. And that's a huge burden. There are no conflicting provisions between Chapter 21 and Chapter 91. Further, to the extent that anything is conflicting, they should be read to be reconcilable because Chapter 91 has a different subject matter than Chapter 21. Chapter 91, if you look at all the provisions, and as the court knows, when you construe a statute, you look at all of its provisions, is about licensing PEOs and regulating the relationship between a PEO and its client. It was mentioned earlier, some provisions of Chapter 91 that deal with who's responsible for control, who's responsible for acts and omissions. Well, that is a provision that says in your contract, you have to say who's responsible. So it's a contractual arrangement between Harbor America and its clients, not between Harbor America and Armand or any of the other employees at the work sites in her position. Essentially, they're saying we were allowed with a different party, Harbor America is saying, to contract away all these employees' rights. And again, going back to that clear case law that says that you can't limit the applicability of a civil rights statute. In fact, there's case law that says even the employee itself cannot waive its right to have its civil rights protected in the workplace. Even the employee Armand could not have contracted with Harbor America to do that. And she didn't. So why can Harbor America contract with Legal Eats to abridge her rights? It can't. Really, those provisions that talk about omissions and acts and responsibilities deal with the rights between Harbor America and Legal Eats. So yeah, Legal Eats was responsible for the acts and omissions to the extent that they harmed Harbor America. So what's the solution there? Not to block Armand's rights, but to allow Harbor America to be indemnified by Legal Eats. And in fact, Harbor America in this lawsuit filed a cross claim against Legal Eats for indemnification, because that's exactly what that chapter means. As this court pointed out, plain language, that's what you look at in the rules of statutory construction. And the plain language of Chapter 91 and its definitions in section 91.001, that's the first section, says in this chapter, Harbor America referenced that it's a co-employer, that Armand was a co-employee. And great if this was a Chapter 91 lawsuit. It's not a Chapter 91 lawsuit, and the plain language of Chapter 91 says you don't apply its definitions anywhere else, just under Chapter 91. So where do we go for the issue of can Harbor be liable to Armand for this workplace sexual harassment? And you go to Chapter 21, obviously, because that's the cause of action. There's no dispute. Harbor met the definition of Chapter 21. The reason why the common law test is at play is because Texas state courts have incorporated the need for a plaintiff, when an employer meets that definition of an employer under Chapter 21, for them to have standing, they also need to have an employment law relationship in most cases. The employment law relationship focuses on control and economic realities. And it was asked earlier, is it control or the exercise of control? Every single case applying this test that looks at control, the factors are listed as the right to control, the right to, or I should say, the right to hire, the right to fire, the right to supervise, the right to set the schedule. There is no dispute that as a matter of law, Harbor America had the right to hire and fire Armand. In fact, in the record, it had Armand sign an employment agreement. It does not say a Legal Eats employment agreement. It says a Harbor America employment agreement. The only place in which Legal Eats is mentioned in that agreement is as the client, not as the employer. Further, the economic realities existed between Harbor America and Armand. And those are the factors for that under the case law are who paid the employee, who deducted their taxes, who provided them with benefits, and who set the terms and conditions of their work. Harbor America paid Armand. It's in the record, her paychecks, they say Harbor America, where it should say employer, not Legal Eats. Further, there was recently an opinion letter by the Attorney General. It said when a professional employer organization pays, it doesn't pay as a money transmitter. This whole framing of Harbor America as a payroll company is not accurate. When you have a payroll company process your payroll, the paychecks don't say that the employer is the payroll company. It says it's your company that hired that payroll company. Here, Harbor America, its name's on the paychecks, and the Attorney General said when a PEO pays an employee, it does so in its role as an employer.
I don't think you cited that AG opinion in your brief. Do you have that cite?
I can get it for the court. It was recently, it was a 2021. I did not cite it in my brief. You're correct. I don't believe I have it here in my materials.
And let me just go back to the control test. So we know we have this hybrid economic realities common law control. And the control test is the more important of the two,
Correct.
correct? And in that test, the courts have looked at whether the employer has the right to hire, fire, supervise, just like you said, and set employees' work schedules. We know that Harbor had the right to hire and fire. And the contract says that Harbor has the right to direct and control employees. I have two questions for you. Is that enough is that tantamount to supervision? And whether your answer is a yes or no, my second question is, how many of those factors do you need to prove control?
Those are great questions. So the first question is, I don't know if it amounts to supervision. There is a provision in chapter 91.032, I believe, and it's restated in the contract that says that the day-to-day activities, I believe, are the responsibility. Well, it says the day-to-day activities in running your business operations. I read that to mean, yes, I have as a PEO the right to direction and control, but I have all these different client companies. Maybe one of them makes sandwiches. I don't tell you how to make sandwiches. I don't tell you how to make engines, that kind of thing. But could that mean also that it's the client company that supervises? Yes, the statute really isn't clear on what direction and control means beyond saying hire and fire. Your second question, I'm sorry, could you repeat it, Your Honor?
Let's see if I can remember it. No, and do you need all four factors, or how many factors to prove control?
Unfortunately, there's no guidance in the case law. I would argue here, though, that the trial court found that obviously, well, the grounds on which it found that there is a common law employer-employment relationship are not listed out in the order. So obviously it found that some combination of the control factors and the economic realities factors in this case amounted to an employment relationship between Harbor and Armand. So the burden then, because the grounds aren't there, is on Harbor to disprove every single theory upon which the trial court could have ruled. So my position would be that while there's nothing in the case law to guide this court as to whether two of those four control factors are enough, the assumption, I believe, is that the trial court found that it was enough. And so Harbor has to disprove all of those factors, and they haven't.
All right. So this hybrid reality test is really to determine whether there's an employment relationship, right?
Yes.
So I'm going to jump forward and I'm going to ask you, if we were, just assume with me that this court were to affirm the trial court, what in your opinion remains to be decided in this case?
Just whether or not there was a hostile work environment or retaliation. So the issue before the trial court, that common law employment and meeting the employer definition of Chapter 21, that was partial summary judgment just on the issue of standing. And so the next part is the actual underlying liability. Now that we know Harbor can be sued, we have to look and say, okay, was there actually a hostile work environment, which is the case law's word for any type of environment, whether it's racial, sexual, discrimination based on disability, and then retaliation being the employee opposed to the discriminatory practice, the hostile work environment, and they're retaliated against. And there's any number of ways to retaliate. And so that's for the jury to decide, did that hostile work environment exist? And was there retaliation? Both, was it motivated by the opposition to the illegal hostile work environment? And was it actually, what the court say, adverse to the employee?
Thank you.
In sum, I just want to go back to the, I realize we haven't fully discussed the economic realities portion of the test. So as a matter of law, Harbor America paid my client. That is both in chapter 91.032 that it had the absolute right to pay. And the interesting thing is, in addition to what I pointed out, how the record shows that Armand's paychecks list Harbor as the employer, it says that PEO has the duty or obligation, one of those words, to pay the employee regardless of whether the client pays it. So Legal Eats could have not been sending the checks, and Harbor America was still on the hook for paying Armand. An interesting thing to point out to the court, there is no private right of action in Chapter 91. Yet Harbor America had to pay these workers. How would they vindicate that right if PEOs weren't subject to other employment laws? Because the only way to vindicate that right to be paid is going to be in the payday law, in the minimum wage law, in the overtime law. In terms of deducting wages, the next factor of the economic realities test, Harbor America, that's the employer name listed on Armand's W-2. That's in the record. And I have those record sites for your honors if you'd like. And its federal employer ID number is on there. That's not something you do if you're just a payroll company. Next, Harbor provided Armand with benefits. And that included a life insurance policy and Texas workers' compensation insurance policy, which, if there's any doubt, should be construed as a benefit because it's not legally required in Texas. An employer doesn't have to have that workers' compensation insurance. Next, they set the terms of conditions of work. In the employment agreement with Armand, they had the right to, Harbor had the right to reassign Armand. And that's really important. It goes back to that staff leasing thing that Harbor brought up. That they say is antiquated language, but really very little of the language in the Professional Employer Organization Act, Chapter 91, has changed since it was called the Staff Leasing Organizations Act. And it says, we can reassign you to a different client. They could have said, you no longer are going to go and work at Legal Eats. Now you're going to go work for one of our many other clients. There are no disputes of fact here. As a matter of law, Harbor had the right to control Armand, and the economic realities existed. Further, not addressed in Harbor's appeal is that another thing the trial court ruled was that the person who harassed Armand, Larry Perryman, was also an employee at common law of Harbor's, as well as the manager that retaliated against Armand. And so we're asking the court to affirm that too, because all these same, because they were a worksite employee at Legal Eats, just like Armand, all these same things apply to them. Right to hire, right to fire, paying the wages, deducting the taxes, providing benefits, and setting the terms and conditions of work. One other thing I want to point out and correct that Harbor America said was they pointed to a provision in the client service agreement, that contract between Harbor America and Legal Eats, and said something about a provision. I believe it's on page 8. Now I have the record site here. It's in the record. It's page 3435. And it says something about the client having exclusive control. Well, that's not the whole quote. If you read that entire paragraph, it says Harbor America has right and direction of control, and everything else after that, the remainder, and I don't have the exact language, I'm paraphrasing, the remainder of the control that we don't have Harbor, that Harbor doesn't have, then you get that control client. We don't dispute that, but what came before that remainder was the right to hire, the right to fire, the right to reassign. And one other thing to point out is the statute, Chapter 91, it says that the PEO and the client share this right. That is true. Under the statute, Legal Eats shared this right. But if you look at the actual contract, and we're still on page 3435, you see that Harbor went beyond that. Chapter 91, that's the minimum of what has to be in the contract. They went beyond that and said, this isn't just a shared right. yeah, you can want to hire someone, you can want to fire someone, but it says you can't do these things without the express permission of Harbor America. They had to consent. So they retained ultimate authority. And when you look at the case law on the hybrid economic realities test, especially De Santiago versus West Texas Community Supervision, which I cite in my brief, they use that term ultimate authority. So the chapter 91, it doesn't really say what share means as far as right to hire fire, if either one of us can do it. But if there's ambiguity there, the contract makes that clear. All the ultimate authority was Harbor's. Legalese could not act in any respect to hiring, firing. It also says changes in pay, changes in duties without Harbor's express permission. So I believe it's clear that Armand proved that as a matter of law, there were no undisputed facts that Harbor America was her employer at common law. And, clearly as it's been discussed, there's nothing explicit in Chapter 91 that would allow it to interfere with any of these other laws. Chapter 91, all its definitions, you stay within the four corners of Chapter 91. It says in this chapter. So it doesn't abrogate Chapter 91. It doesn't abrogate the common law, which just like the statutes, the courts also are supposed to be wary about abrogating the common law. Just because it's not in a statute doesn't mean, willy-nilly you overturn it because of another statute. It has to be the language. It's in a case called Waffle House. It's cited in my brief. It says there has to be a clear repugnance between the two. And because any employment relationship that might be defined as Chapter 91 remains in Chapter 91, there's nothing that is inconsistent with Chapter 91's existence and application, which shouldn't even be applied to this case because this isn't a Chapter 91 cause of action. It's a Chapter 21 cause of action that incorporates the common law test. There's no clear repugnance between the two. So we're asking the trial court to affirm, this court, to affirm the trial court's decision. First, that Harbor America, which doesn't dispute, was an employer as defined by Chapter 21, that it had a common law employment relationship with Armand, that it had a common law employment relationship with Larry Perryman, and that it had a common law employment relationship with Melissa Rose is the third person.
Before you go,
Yes.
it looks like you're wrapping up or you've
Yes.
wrapped up. I know you've talked about that there has to be a clear repugnance between the two statutes. But can you just briefly address 91.002C of the labor code? That's the one that talks about notwithstanding any other provision. Nothing in this chapter preempts the existing statutory or rulemaking authority. Are you familiar with that?
Yeah. Well,
I can read the whole thing.
I mean, I
Do you think that is that important or not very important? What is your
I don't-
opinion?
excuse me, Hunter, I didn't mean to interrupt. Well, one thing real quick, that repugnance rule is about common law preemption, not two statutes.
Okay,
Construction. Secondly, I like that section because Chapter 21, which is what we're suing under, creates statutory authority for an agency, the Texas Workforce Commission. And so if you say Chapter 91 precludes Chapter 21, well, right there, as Chapter 90, Section 91.002 says, you're interfering with the rulemaking and enforcement authority of the Texas Workforce Commission. So I like that section. I think it works in our favor.
thank you.
All right. Thank you, Your Honors.
Thank you.
So to get back to the Chapter 21 issue, the general rule as cited by the appellee is that the two statutes have to have the same subject matter, which is definition of an employer, which I think we have here, and that they're irreconcilable, which they clearly are.
Well, let's just assume that maybe that's not so clear.
Okay.
And aptly argues, in fact, that there are two very different statutes, that they might still contain the same definition of employer. But one seems very specifically applicable, especially to sexual harassment cases, and the other doesn't even talk about sexual harassment. How are they clearly the same subject matter?
Because they define who's the employer and who is not the employer.
As I just said, what I understand is that the only similarity between the two chapters, as you propose, is that simply because they both contain the definition of employer, that they then, the entire statute applies to the same subject matter. How so? Because there are other statutes that also contain their own definitions or similar definitions contained in other statutes. It doesn't necessarily support the argument that each of those statutes are all apply to the same subject matter.
Again,
And not just for two statutes to conflict, they must deal with the same subject matter or purpose. And if they do, the next question is whether they actually conflict. So how are they under the same subject matter?
because the acts and under chapter 91, the acts, first, I'd like to point out under 91.032 of the Texas Labor Code, section B, there's the big list in section A that says shares this right, shares this right, shares this right. And then in subsection B, it says notwithstanding that. And then that's where it says the acts, the errors, omissions of the worksite employee. But to get back to your question, Your Honor, I don't see how it can be an act, an error or omission is an act is sexual harassment. I mean, it is the subject matter being who's the employer and the act being sexual harassment, which is irreconcilable, which makes chapter 91 irreconcilable with chapter 21. And then despite the appellee in his her SIR reply, not wanting to get into the economic realities test, I was prepared to argue that because I've done it in other cases involving the exact same issues. When it started, I'll kind of walk you through the evolution of how they decided who's the employer. And I mean at a federal level, up to the Supreme Court. And the IRS Chief Counsel Advisory said when a leasing organization merely acts as an agent or employer, providing payroll and other services without legal responsibility for the payment of wages, which we know is not the case here, they were responsible. The leasing organization is not the 3401D1 employer, and that's IRS Chief Counsel Advisory, IRS CCA 2001-03-070, January 19, 2001. The advisory cited 3 cases, which for brevity's sake, I won't go through, where an employee leasing company was held to not be the 3401D employer or the common law employer, for which in the common law employer context, the court tends to look to the master servant or some sort of agency over the employees. This was utilized by the U.S. Supreme Court in Community for Creative Nonviolence versus Reed. That's 490 U.S. 730, 1989. Later, the Supreme Court heard Nationwide Mutual Insurance versus Darden, 503 U.S. 318 in 1992, and came to a similar conclusion as it relates to an ERISA issue. After that, and relying on Darden and the U.S. Supreme Court, the EEOC crafted a test to be applied in its cases. Courts generally now apply that economics reality test, which deal with mainly come into play in FLSA violations, and they look to the nature and degree of the punitive employer's control of the workers, which we know they didn't have any, I mean, they shared the right, but they didn't exercise that right. The degree of supervision, direct or indirect, of the work was non-existent. 3, the right to directly or indirectly to hire, fire, or modify the worker's employment conditions was present. 4, the power to determine the worker's pay rates or methods of payment. The methods of payment is arguable. The worker's pay rates was set by the client company. The preparation of payroll and the payment of workers' wages. They did prepare the payroll and pay the workers' wages, but it was only after receiving payment from the client company. The ownership of the facilities where the work occurred, that was clearly at the client company level. Whether the worker performed a line job integral to the end product, that's clearly the client company. And the relative investment in equipment and facilities, which clearly falls upon the client company. So respectfully, Your Honors, I would request that the trial court's order be reversed and that Harbor America be dismissed from this case.
Very good. Are you giving court back time?
I'm sorry?
Are you giving back the court some time?
Sure.
Very good. Thank you. This case is now submitted and an opinion will be forthcoming. Court is adjourned. Oh, before I do, I'll invite counsel for appellee to submit a letter with that AG site. And of course, there's any citations that you might have referred to that were not contained in your brief, you're welcome to equally submit said letter.
Thank you.
Thank you. Court is adjourned.
Thank you.